And I will leave it to Jasmine Beck to introduce her to you in a moment. Just to say a couple of words about the Global Research Network. We're really a meeting place for early career researchers as well as senior scholars to discuss their work, to support one another. And we're really here to be a home for people to connect and grow together throughout their careers, because so much of the time we're bouncing from university to university, from city to city. And some people are also at institutions that don't necessarily have the resources to connect people to a sort of global audience and to colleagues or potential colleagues around the world. So we're here to facilitate things like these events, to facilitate discussions at our research groups, our coffee house meetings, and so on. If you're thinking about joining, you can do that online on our website, www.grn.global. And yes, I hope to see you soon, hope to meet some of you. And without further ado, I'd like to hand over to Jasmine, one of our leads for the program.
All right, thank you so much, Yuriko. And good afternoon from my side too. Before we take a closer look at two particular manifestations of discriminations, I will just briefly introduce today's speakers. And to start off, we are honored to be joined by Professor Sibony from the University of Seville in Spain. And we could actually spend the whole hour, I think, just discussing the rich experiences contained in her CV, but I will just mention a few aspects of it. In addition to working as a practicing lawyer, Professor Sibony currently teaches various courses, including migration studies, private international law, and specialized courses related to gender equality and gender-based violence. And she has also published widely in these fields and has worked together with public and private actors to strengthen the protection, including of non-nationals from gender-based violence. Then, following Professor Sibony's input, my colleague Preeti, who recently authored a chapter about law and policy in the context of COVID-19 in Asia, is going to lay the context for the issue we're going to look at in the Indian context. Preeti is a doctoral scholar at Lancaster University in the UK, researching on the practices of untouchability. She has recently presented joint statements with our colleague Amit, who is going to provide the last input for today before the UN Committee on the Rights of Persons with Disabilities, the UN Committee on the Elimination of Discrimination Against Women, and before the UN High Commissioner for Human Rights. Amit is, like Preeti, also a PhD candidate at the University of Lancaster and an LLM graduate from the University of Reading. And he is going to address the specific issue of witchcraft. And after that, I hope we still have ample time for questions from the floor, which I'm very much looking forward to hear. Now let's approach the question, what is needed for particular anti-discrimination laws to work in practice? Professor Sibony, thank you so much for accepting our invitation, and you have the floor.
Okay, good afternoon. First of all, I would like to thank the Global Research Network think tank, especially Mrs. Jasmine Beck, for inviting me to this panel discussion. In keeping with the program, I will offer you a brief talk about migrant women, victims of gender violence, and the application of Spain's immigration laws. Please remember that this is an extremely complex legal matter that cannot be outlined in just 15 minutes. So I will focus on residence and work permits due to exceptional circumstances, specifically victims of gender violence. I will not deepen into the many other permits covered by Spain's immigration laws. Another important aspect, a very important aspect, is that within the European Union, there are no common immigration laws. Each member state has its own laws. Nevertheless, they are obliged to incorporate European Union dictates by means of directives and regulations into their own legislation. Otherwise, member states would be sanctioned by the European Union, as you may suppose. In Spain, we have three different immigration regimes. The Comunitarian regime, Royal Decree 240/2007, the General regime, Organic Law 4/2000, and the Special regime for refugees, displaced, and nationless people, Law 12/2009, but I will not be covering this latter. Consequently, when counseling migrant women, the first task is to know where she's coming from, country of origin, and her social family situation. That's the only way to know which regime is applicable, because outside of these three legal situations, foreigners are considered irregular. It may be said that migrant women suffering from gender violence are double victims. On the one hand, they have suffered violence, and on the other hand, they find themselves in a foreign country from which they may be deported. This situation of vulnerability demands integrated legal advice, not only in terms of immigration law, but also regarding other matters, all of which is guaranteed in Spain. For example, the right to child custody after divorce or the breakup. In many cases, the aggressor usually tries to coerce or control the women. From a criminal standpoint, Spain is a member of the Istanbul Convention, applicable since August 2014. But its integrated law against gender violence has yet to be adapted to this convention, despite it being binding. I must point out that in Spain, there is a clear difference between gender violence, which is committed by the male, who is or has been the partner or spouse of the female victim, and domestic violence, which is committed in the home by any of the members of the family as specified in Article 173.2 of Spain's criminal law. Nevertheless, current legislation is being revised in order to consider gender violence as any form of violence against women, as considered in the Istanbul Convention, including situations outside the context of the partner and ex-partner. It must be said that the legislation of Andalusia has expanded the concept of gender violence, but in the sphere of criminal and immigration laws, we still have to apply the national legislation. Okay, so it takes a look at the Comunitarian regime. And the question is, to whom may it be applied? We have to consult the Article 2 of Royal Decree 240/2007, and this article does not take into consideration the country of origin in the following cases. The spouse, where the marriage has not been annulled or the couple is not divorced, the partnership that is legally registered in a public register of a European Union nation or in a country within the European Economic Area Agreement, and the partners that are not officially registered, they may obtain a Comunitarian family permit if and when they provide proof that they are together continuously for at least 1 year, unless they have children in common, in which case they have only to certify a stable coexistence. Direct descendants, both of them, who are younger than 20 years of age or older than that, but they are living with their parents, or if they are disabled. And the dependent ascendants of both of them in the direct line, for example, my mother, my father, my grandmother, or my grandfather. So we have 4 cases in which it is not important the country of origin to apply the Comunitarian regime. You must know that this regime is not only applicable to European Union citizens. And regarding to the Comunitarian regimes, we may apply the rules of Organic Law 4/2000 in those aspects that could be more favorable as specified in Article 1.3 of Organic Law 4/2000. Okay, this permit allows you to live and work in Spain for 5 years. It is the most common option when your spouse or partner is a European Union citizen or from a member nation of the European Economic Area Agreement or from Switzerland. And when the time comes to renew, and if requirements are still maintained, it is possible to obtain a 10-year permanent residency permit. To request this permit, the European Union citizen must prove that she has a minimal economic income to avoid becoming a social burden, a social problem in Spain. But problems begin when the woman decides to divorce or to end the relationship. Then coercion may occur from her partner. What would happen then? The answer lies in Article 9 of Royal Decree 240/2007. This law offers guarantees to stay in Spain under certain situations. For example, if the woman obtains the custody or visitation rights of her children, among other possibilities. Another question is, what happens in the case of family reunification under the general regime? Does a woman lose her rights? Remember, now we are analyzing the general regime, not the communitarian regime. Imagine that an Ecuadorian woman is regrouped by her Ecuadorian husband or partner. Remember that the general regime is only for foreigners whom are not eligible for the communitarian regime, nor the special regime for refugees. In that case, the woman could get an independent residency and work permit due to gender violence or domestic violence. And once the courts have issued a protection order, or in the absence of this order, a report from the district attorney indicating the existence of gender violence. The woman could also get an independent residency and work permit if she's getting divorced from her spouse or the partnership dissolved. But in this case, she must provide proof of cohabitation with her reunited spouse or partner in Spain for at least 2 years. This permit allows to live and work in Spain 5 years, and when the time comes to renew, if it's possible to obtain a long-term residency permit. Finally, what happens if the woman is an irregular migrant and the victim of gender violence? Article 31 bis of Spain's immigration law is applied, specifically Organic Law 4/2000. When faced with gender violence, a woman has the right to request a temporary residency and work permit once the protection order is issued, or in the absence of this order, a report from the district attorney indicating the existence of gender violence. This authorization is considered definitive when the aggressor is sentenced or is court ruling from which it may be deduced that the woman is a victim of gender violence, but without obtaining a guilty verdict due to the fact that the case is shelved because the defendant's whereabouts is unknown or he has been deported. This concession is not issued automatically. The woman must request it. That's very important. It's a very important point. This concession is not issued automatically. Women must request it. As long as the court case is ongoing, there is no deadline for the request. However, when it has concluded, there is a 6-month limit, which begins once the victim is notified with a verdict. Remember, once the deadline has been reached, the exceptionally residency and work permit due to gender violence will not be granted. This authorization is granted for 5 years. After that, the woman may request a long-term residency permit, in which case she need not provide proof of income. It is important to know that in Spain, an irregular migrant woman who is a victim of gender violence should not be afraid to go to the police. The authorities may not launch a deportation process until after the criminal case due to gender violence. In those cases in which the deportation process has begun, it is suspended until the courts have ruled. But in many cases, it is not easy to prove the gender violence situation. And when the aggressor is acquitted, a request to deport the woman may be presented. But the police must first locate her to start the process. It is not automatic. I must say that excessive bureaucracy can easily hinder foreigners' access to rights that are legally recognized by Spain's legislation. The digitalization of requests and procedures has made the entire process more difficult. Officialdom seems to have forgotten that not everyone has a computer and many are not computer educated, whether citizens of Spain or foreigners. Face-to-face alternatives are essential. This is especially true when deadlines must be met and fundamental rights come into play. In conclusion, Spain's immigration rights offers the necessary tools to protect migrant women, victims of gender violence, as specified in Article 59 of the Istanbul Convention. However, the authorities, specifically the police and courts, do not always interpret and apply the rules correctly. And appealing does not guarantee rights when migrants have been returned to their country of origin. It's important that migrants stay in Spain during the process. What should the European Union do? In my opinion, the European Union Court of Justice should protect human rights. It is unacceptable that there are still human rights violations and nothing is done against human trafficking that places women and their children at risk. It is hard for the European Union to respond to the problems of immigrations and refugees if it fails to articulate effective common legislative policies. It is equally difficult for member states to accept blanket immigration, asylum, and refugees laws, as they have a direct effect on national sovereignty. The European Union seeks to move forward with family reunification, the regulation of long-term residence and labor integration, and the access of common policy. But that's not enough. Just take a look at the Mediterranean Sea. It has become a cemetery that has taken the lives of thousands who one day boarded a flimsy fishing boat in the hope of escaping war and poverty. It's terrible. Those corpses bear the names of equality and 21st century slavery, which is none other than human trafficking for sexual or labor abuse. We are faced with a complex matter with no easy solutions that the European Union can only handle effectively with unified criteria on behalf of its member states until full legal and common coverage is obtained. The importance lies in a migratory strategy based on human rights, one that places the migrants at the center of political policies. Immigrations need to be coordinated much better by the European Union while paying special attention to national plans of action to combat racism and xenophobia. I hope that this information has been useful to understand Spain's immigration laws, and in the case of gender violence specifically. Thank you for your attention. Should you have any questions, I would be happy to answer them. Thank you very much.
Thank you so much, Professor Sibony. You really managed to illustrate a lot of the legal complexities and the effect of the persons on the persons concerned by those complexities in just 15 minutes and pointed to some really important points of action. A lot of this will hopefully be taken up later by the questions from the audience. Now, Preeti, I hand you the floor to lay the context for the issues we're going to look at in the Indian context.
Well, it's lovely to be here today as we discuss legislative amendments, measures against discrimination. We've had Professor Siboni speaking on European scenario so far. So right now I'm going to give talk briefly about the Indian scenario so that Amit can then continue from it. So as you all know, India is a very diverse country. It's multicultural, it's multilingual, and it's multi-religious. So this being the case, discrimination is woven to the very fabric of the Indian society, and it's been so for centuries. So various types of discrimination that based on caste, race, language, religion, place of birth, sex, and so on. So in such a heterogeneous society, bringing an anti-discrimination law can be a humongous challenge to any lawmakers. So to those who are not aware of caste, the chief architect of the Indian Constitution, Dr. B.R. Ambedkar, he defines caste as an artificial chopping off of the population into fixed and definite units, each one prevented from fusing into another through the custom of endogamy, that is marriage from within the community. So the caste system is basically like a multi-story building. So you're born there, you live there, and you die there. So there's no mobility. You can't go like how it is in class system. You can go from working class to middle class and upper class. That kind of mobility is absent in the caste system. So some of the first credits in bringing anti-discrimination laws in India go to the British Imperial Crown when India was her colony. It enacted certain penal laws like the Indian Penal Code, which treated every person equal under the eyes of law. And the punishment so awarded for a crime was based solely on the crime committed. So this is particularly important since till then, the ancient Indian laws like the Code of Manu, they awarded different punishments to the same crime based on the varna of a person. For example, if a person belonging to a higher varna was to commit an offense, he would be let off with little to no punishment at all, while a person from a lower varna would be severely punished for the same offense. So the Indian Penal Code was an equalizer as far as criminal justice system in India is concerned, in particular context of caste. So then the British Crown also introduced affirmative action based on religion in India. So credits must also be given to the native rulers like Chhatrapati Shahu Maharaj of Kolhapur and Nalvadi Krishnaraj Odear of Mysore, who incorporated affirmative action policies in their administration, whereby seats were reserved for the downtrodden in education and employment. So the first school for girls was also started in 1848 by Jyotiba Phule and his wife Savitribai Phule in the present state of Maharashtra. So all this shows that how discrimination is ingrained in the very Indian soil, and men and women fought against it, suffering huge personal loss, but they were determined to bring about change in the society. So when India then became independent in 1947, one of the mammoth tasks before the Constituent Assembly was to draft a constitution which would bring in equality in such an unequal society, and the rights of the last person would be guaranteed and protected by law. So keeping this in mind, the framers of the Indian Constitution specifically set out goals in its preamble. And it constituted India into a sovereign, socialist, secular democratic republic, securing to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, ensuring the dignity of the individual and the unity and integrity of the nation. So these are the golden goals that run throughout the fabric of the Indian Constitution. So the basis from which the present anti-discrimination laws in India derive their legitimacy is the Constitution of India. So in Article 14, the Constitution clearly states that the state shall not deny to any person equality before the law or equal protection of the laws within the territory of India. Now, this article is further embodied in the anti-discrimination provisions, such as in Article 15 and 16. Where Article 15.1 states that the state shall not discriminate against any citizen on grounds only of race, religion, caste, sex, place of birth, or any of them. Similarly, Article 16.1, it states that there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. So then comes one of the most important articles in the Indian Constitution, that is Article 17, which abolishes untouchability and forbids its practice in any form. The enforcement of disability arising out of untouchability shall be an offense punishable in accordance with law. So then we have many similar articles. We have Article 19, which provides various kinds of freedom to Indian citizens, like freedom of speech and expression. There's freedom to practice any profession or to carry out any occupation, trade, or business, which till then were not available to all. So like I mentioned before, the ancient Indian laws governed by the Hindu scriptures, they restricted a person's behavior and just life in general based on the caste he was born into. So, but this was the Constitution's way of saying that birth never decides worth. And we have Article 21, which is one of the most important articles in the Indian Constitution, which guarantees to every person the right to life with dignity and personal liberty. So I've basically highlighted a few provisions here to show that this Constitution, propounding all these anti-discrimination provisions and egalitarian values, is born in a soil which is essentially undemocratic. So a lot of legislations which are aimed at anti-discrimination have been enacted after the adoption of Constitution in 1950, but still wide-scale discrimination is witnessed in almost every sphere in the Indian society. So I can possibly think of two reasons for it here. And firstly, there is clear lack of political will in the ruling dispensation, past and present, to enact stringent laws without loopholes, so they cannot be misused. So I'm not blaming the present dispensation. It has been the case with successive governments. So there has been a failure to enact strict laws without loopholes. And secondly, and this is very important, that I feel India is going through a very complex transformation. That on one hand, there are the Hindu religious scriptures which propound the doctrine of inequality, and on the other, you have the Indian Constitution, which propounds the doctrine of equality. So the mindsets of people are rooted deeply in the religious scriptures, due to which there is still a prevalence of discrimination, be it of caste or gender. So I believe a lot of work needs to be done in this regard, so that the anti-discrimination laws so enacted can serve the true purpose of their enactment, and we can hope to live in a just and egalitarian society. Thank you.
Thank you so much, Preeti. Truly a contrast to the European situation, but also some similar themes that I hope we will be able to take up at the end of the discussions. Amit, I hand you the floor.
So in my presentation today, I'll be talking about the harmful traditional practice of witchcraft in India, and also about the reasons why, despite prohibitory legislations, this practice still continues in 21st century India. Now, the term harmful traditional practice or harmful social cultural practice is often used to denote various forms of violence against young girls and women, such as female genital mutilation, honor killings, child marriage, etc., that are often committed in societies which are governed by patriarchal values and beliefs. Now, these varied forms of violence against women are often justified in the name of tradition and culture by the perpetrators, and are even condoned by the society at large. The normalization of these harmful social cultural practices in traditional societies is also seen as a major hurdle in the true realization of international human rights law on the ground. Now in India, where gender hierarchy is believed to be the norm, women have struggled for equal rights in the past and they still continue to do so. In addition, in the Indian society, religious, cultural, and traditional aspects have been found to play a fundamental role in shaping the entire discourse on women and their rights. Although the Indian Constitution, as Preeti said, guarantees equal rights for all, however, in practice, the subordination of women exists in society mostly because of customary practices that often advocate gender discrimination. Now, harmful traditional practices that are condemned by feminist scholars as oppressive in nature demonstrate how gender is used to build hierarchies and clearly mark out the difference in power relations between men and women. But this distortion of gender either remains hidden or is ignored despite repeated incidents of violence against women that are carried out in the name of social cultural norms. Now, witch hunting or witchcraft accusation is one such form of harmful traditional practice which is prevalent in contemporary India. Now, killing and torturing of individuals in the name of harmful beliefs and practices associated with witchcraft has taken place in several societies across the world, such as Europe, Africa, South Asia. The belief in witchcraft has also given rise to serious human rights violations, such as public beatings, banishment, and even cutting of body parts. Such punishments are common in societies that strongly believe in sorcery, magic, superstition, or attribute any misfortune to supernatural entities or malevolent spirits. Women, children, the elderly, persons with disabilities, such as persons with albinism, are some of the most affected people by witchcraft-related violence in such societies. In India, as per the National Crime Records Bureau, between 2001 and 2014, a total of 464 women have been killed as a result of witchcraft allegations in just one particular state. Further, more than 2,000 people have died in that same period, that is between 2001 and 2014, across India due to witchcraft accusations. Now, the practice of labeling women as witches and thereafter inflicting various forms of physical violence upon them is hardly a new phenomenon in India. Women belonging to the marginalized communities are often the main target of such practices, especially Dalit and tribal women. Superstition is, like I said, the most common factor behind labeling a woman as a witch, since it acts as a powerful tool in the hands of the patriarchal and feudal setup to maintain subjugation of marginalized women. Superstitious beliefs, which are strengthened often by folklore and myths, they allow for malicious intent to spread rapidly within a community and create a sense of fear, which is used by powerful groups to dominate and control women. An example of a superstitious belief prevalent in one of the states in India, that is Rajasthan, is that women belonging to the Dalit community are more vulnerable to being attacked by dark spirits because they clean human waste. Now, another reason behind witchcraft accusations in India is property dispute. Now, labeling a woman as a witch is seen as one of the easiest ways to get hold of a property. Mostly widows and single women are accused of being witches by one of their relatives with the intention of grabbing onto their property. Infertility in women in India is viewed as a disability and is seen as another reason for labeling a woman as a witch. Any physical deformity in any woman is also a reason for accusing her of being a witch. Another important factor is that of personal conflict and caste rivalry. Now, because of personal enmity or when a woman protests sexual advances by a man belonging to a dominant caste, she is branded as a witch. Now, the answer as to why only women are branded as witches while men are always the witch hunters lies in understanding the structure of society in which such a practice takes place. Now, in India, men often control gender relations through various rules and regulations that are imposed on women, and when women do not abide by them, they are punished. Now, this punishment ranges from rape, domestic abuse, and other gender-based crimes. Witchcraft accusations is another example of such a punishment. the assumption that women are essentially to be kept under control and that their behavior is to be monitored at all times is one of the core beliefs of the Indian social system. Witches, a personification of evil, are almost always women, and witch doctors or witch hunters, the symbols of power and good, are always men. The relationship between witches and the witch doctor is clearly a reflection of deeply embedded patriarchal values within society. These reinforce the idea that it is the men who are authorized to control and prevent women from going astray, that their power is strong, necessary, and positive, and any power that a woman acquires is regarded with suspicion and as seen as negative and destructive. In other words, men use their power constructively and legitimately, whereas women's power is unauthorized, harmful, and needs to be controlled by men. Men and women are conditioned to believe and perpetuate this belief with serious consequences for gender equity. Now, coming to the issue as to why this practice and similar other exist in India despite prohibitory legislations, I would like to point out that regardless of the many reasons behind existence of witchcraft or other similar practices, the important question is how far has the Indian society addressed the issue of normalization of violence against women, including the practice of witch hunting, considering the point that there is an intersection of a lot of factors, including gender, which obviously is linked with issues of social factors of family, caste, religion, etc. More importantly, have women who are the main targets, for instance, of witchcraft accusations, have they been able to make use of constitutional guarantees and existing legislations to make a claim for their rights, despite existing systemic and structural constraints? In other words, in a pluralistic society such as India, with a diverse nature of community governance systems, which are often rooted in patriarchy on one hand, and you have the formal legal institutions on the other hand, has the state been able to protect the rights of women, especially marginalized women? Now, the various issues related to witch hunting or witchcraft accusations also provides a setting to understand this the complex manner in which social cultural norms and values that have existed for a long period of time compete and coexist with formal law in India's multicultural society. Now, acknowledging this competition between contrary legal positions, that is formal law, which is modeled on accepted international principles, and non-state laws, which are based on community beliefs and norms or superstition, myths, folklore, you can call it whatever you want, that most of them often reinforcing patriarchy. And this acknowledging this competition is also vital from a gender justice point of view. Now, in the Indian setting, similar to most traditional societies, the understanding of human rights, justice is intricately linked with social cultural factors of family, religion, community, caste, and class. And the intersection of these social cultural factors exerts influence and affects individuals' ability to negotiate their claims to justice. Now, finally, in India, human rights norms, they continue to be intertwined with an individual's social relationship and social practices in a legally pluralistic environment. Therefore, I'd like to conclude by saying that it is crucial to first and foremost, acknowledge those important aspects that play a significant role in shaping the relationship between formal human rights protections and informal grassroots practices. And these crucial aspects, are associated with the role of formal versus non-state laws and how parties and their family members perceive the effect of these formal and non-state laws in their daily lives. Further, what factors affect the workings of both formal and non-state laws, since non-state laws, as I already mentioned, are often based on customs, traditions, practices that are rooted in patriarchy, and they have a significant role in ensuring the continuity of gender discriminatory practices. Thank you.
Thank you so much, Amit. Amazing. So anyone who would like to directly ask a question, please feel free to raise your hand or write in the chat at the YouTube live stream. We have one question in the chat here. I don't know if okay. And that is that Professor Sibony, you mentioned there's a solid legal framework, and Preeti, on the other hand, mentioned that the law isn't solid enough. It has loopholes. And in both contexts, however, we notice that implementation is lacking, or there are flaws in the implementation. And then our commentator in the chat mentioned that all the formal changes we can make might not be enough, and there has to be a complete social overhaul, and quoting. So maybe you would all three of you make a few comments on, I think Professor Sibony, you've already pointed out some great points. Some comments on how, particularly in what is needed in the implementation. Is it more really just communication with victims and the implementing officers, police officials who have the first contact with victims, or would you point out to some other aspects for improvement as well?
I don't think that this is a problem of communication, because we have translators and police. They make the protocols really good, but the problem is that our authorities needs to be updated with respect to immigration laws. And migrants shouldn't be deported while process is ongoing. That's the problem. And I think it's more a political problem, because in Spain, we have, the autonomous communities. And, I think you have read it, newspapers and magazines. The opposition is all the time fighting with the government, and those problems are really, really important, because it avoids to advance. We need, a politically unified criteria, and that's a problem in Spain at the moment.
The implementation is basically disastrous in most of, as far as the anti-discrimination laws are concerned, in India especially, primarily because the people who are implementing are also people from the same society, which are based, and they are having the same identities. Say, for example, especially when it comes to caste or gender, these identities play out in their own way. So I agree with the comment which is written by a person here, that the social system needs to be changed, but the point is, how do we change it, right? It's not something which happens overnight. It's a process, and in that process we have come so far, and our laws are helping in that regard. But the implementation authorities are also part of the society, because of which the problem persists. So conscious efforts has to be made, and see, as you say, constitutional morality has to be cultivated. It is not a natural sentiment. It doesn't happen like how religion is, right? So constitutional morality has to be cultivated, and children have to be groomed in that way right from their childhood, from their school time. You have to have these kind of values inculcated in them right from their primary school, so they can grow up and become citizens where they change these social structures, and then you can see some sort of change happening in the society. So that's what I think.
Yeah, I just want to add one more point to what Preeti has already talked about. It's about ensuring proper implementation of the existing laws, and one way of doing that is by including people for whom the law is made. So when the legislative process, begins, so there should be, enough. I mean, the state should ensure that the people for whom the law is going to be made, they are included in that process, and you should have representatives from, such communities, vulnerable communities. You should have representation from those communities, so that the real problems, get addressed in these laws, and there is some scope for ensuring that justice is, in a way, delivered to these people. And whenever they come to, these formal legal institutions, they have the correct claim, and they have some, hope of getting justice. But if the law has been, in a way, made without, having proper consultation, so to these communities, to the vulnerable sections of the society, these formal laws or the formal institutions, then they appear to be completely alien, and that's a major, point for the ongoing distrust between, communities and formal legal setups, and that's why you have these communities falling back to their own local governance systems, which often do not, govern themselves by the rule of law. So they only cater to the most powerful or the most dominant people in that locality, and often these do not take into consideration principles of natural justice, or they often do not, are not gender equitable. So yeah, that's what I had to add, that there has to be, proper consultation before moving forward to, bring in laws and ensure proper implementation to help, communities.
We have two questions in the chat, which I invite everyone who has an answer to answer. One is whether it's directed to the speakers, whether you consider a top-down or a bottom-up approach to be more effective, and also asking for best practice examples from around the world.
Okay, I'll go with one of the questions. Whether a top-down or a bottom-up approach. I think revolutions across the world has always been from the masses, and it has always been from the ground. So unless you hold the ones on top accountable to something, I don't think there has ever been a successful revolution if you take a history of any part of the world. So I think a bottom-up approach is the one which will give us result, maximum result, so to speak. So yeah, I'll go.
Yeah, even I agree with what Preeti said, that a bottom-up approach usually, which is it gets, like, the maximum and the most effective results, and at times it is, it's although it's considered a short-term, goal, but considering the nature and the whole background with which these bottom-up approaches, say for instance, if there is an amendment required in in laws governing rape, and because there are so many incidents that come to the fore, so that in a way riles up the community, and you have people effectively making those amendments to ensure that maximum punishment is awarded for such an offense, and so like Preeti said, that these kind of quick and effective and short-term goals or short-term remedies are achieved often by through the masses and through the when people come together, or people who are affected come together and make a noise about it. So because if you leave it to the legislators, and if you leave it to the society at large to address human rights violations which are which often nobody talks about. At least people don't generally talk about violence against women and young girls in a manner in which they should. So if you leave it to the legislators or the society at large, then change often doesn't come that quick, or it's not that effective. So unless you educate people about such issues, and by educating them, you also instill in them the value to come together and demand for their rights, then I don't think a top-down approach. It's not that it doesn't have its own merit, but in situations like this, when human rights violations are concerned, often a bottom-up approach is more effective.
I also think that the Spanish example would be interesting here, because the change or the law against gender-based violence came up after a very famous case, and I wonder if also then the amendment which introduced the residence permits was also a form of a bottom-up thing, where people said, well, we have this law now, but it's not working for people who don't have a fixed residence status. So maybe you can comment on that, Professor Sibony.
No, I think you have the possibilities. You have it by Spanish law. Also, like as I said, the tools to get those work permits or residence permits. The problem is if you're not a victim of gender violence, there's really difficult to get them. But this would be another aspect to discuss in another panel discussion, because you can't explain it in 15 minutes, like as I told you, and it's difficult because immigration laws are really complicated, and immigration is a global problem. And as I said, immigration laws have a direct effect on national sovereignty, and we're not alone in Europe. We have to work together with the European Union, and this is not easy. But in my opinion, as I said, Spanish immigration rights offers really the necessary tools to protect migrant women victims of gender violence. Another question is if you have to apply the asylum rights, and that's not easy. Or the problem what we have in Ceuta with people who came from Morocco or from Africa, it's really a difficult problem to solve it. But when we are talking about gender violence, rights are really guaranteed. You can get an lawyer without paying them, it's guaranteed. And this lawyer is really updated in immigration laws, but the authorities are not. They have to learn they're not really updated in what immigration laws means. And that's a problem. That's a problem. And to prove this gender violence is also difficult. The proof is difficult, but the rights, the immigration rights in Spain, they are covering these situations as specified in the convention, in the Istanbul Convention. I think you are working about your doctorate, no? It's going on about the Article 49?
59, yes, correct.
Sorry, 59 of the Istanbul Convention. And this article, it's really incorporates in Spanish rights, in Spain's immigration rights. It's incorporated. It's not a directive, but it's a treatment, and it's being binding. But the problem, it's not really what is going on with gender violence, with the women who are suffering gender violence. The problem is really what is going on with all those people who are coming from Africa, no? Because they're escaping of war and poverty. That's really the problem. And the European Union is not, has not a solution at the moment. That's a really problem.
Thank you for these comments, and they're actually the perfect end to our little hour, because we are going to have another panel discussion in a few months, at the end of November or beginning of December. So do follow the Global Research Network to be updated on that. And there we will be talking more about the protection from violence of migrants, both in Central America and Europe. So hopefully we can talk about the issue you just mentioned there. Thank you so much for joining us. Thank you so much for the discussion. I think it was a lot. It's hard to squeeze it all in 1 hour, but it's also hard to grasp all the complexities in 1 hour. So thank you very much for joining us.
Yes, it's a complex legal matter. It is. It's really complex, and the solution, it's difficult. I know that, because we're not working alone by immigration laws. We have to work together, and that's a problem. I think maybe the European Union, Parliament and the authorities should control more what is going on in the different member states.